All right. Thanks everyone for joining today. I'd like to introduce Lisa Dillman from Applegate Dillman. She's our presenter today. This is our third in the series of three. And if you have friends or others that have missed it, the other parts 1 and 2, those are available on our website through our YouTube channel. There's a link there. So anyone can just email me and I can give them that link, or they can just check out our website. So let's just move forward with Lisa and her presentation. And why don't you give us a little bit of information about you first and then go ahead and get started.
Sure. Thanks, Barb. I'm Lisa. I'm an elder law attorney and I practice. Carol Applegate and I joined forces about 2 or 3 years ago in building our firm together. I have been a lawyer for, I'm afraid to even say how long, 28 years. And my first 10 years, I was in the courtroom and doing battle on a daily basis. And then when you're the only lawyer in the family and somebody has a legal problem, your phone rings. So the legal problem was that my grandmother had had a stroke and she was headed to long-term care. The twist was that she was the owner of the family farm that my uncles worked on. So if she lost the farm or had to sell the farm to pay for her care, that was putting at least 2 families out of work and it was going to be a mess. So they called, they were distressed, and I learned elder law in a crash course, baptism by fire. But I'm so grateful. It's one of those divine interventions. I'm so grateful that I did, because as I kept going in my education in this area of the law, I realized that every family deals with those kinds of situations, and maybe multiple times in their journey. And there's just not a lot of professionals out there who specialize in this area. So the demand was high and the supply was low. So I'm just glad that I found my path there. So that's what I kind of want to talk about today. Before we get to the saving the family farm crisis, there's some pretty easy, straightforward things that you can do to put yourself on the right path, to do some really basic, simple planning that will save you so much heartache and so much trouble down the road. So I kind of want to talk about what I call the 3 or 4 phases of planning that will set you up to avoid maybe some imminent disaster. So let me share my screen. I'm a PowerPointer. I need my slides as my whoopee. So, all right. Can everyone see that okay? All right. So essentially, and I know that you've heard Carol speak a couple of times, so she's probably already educated you with respect to what we do in our practice. But the most important thing is that we help our clients and their families develop a plan, a holistic plan for future needs with the least financial impact. So even some of that basic, simple planning that we do right at the very beginning, it is designed for or intended to minimize the financial impact of long-term care and conflict and things like that. And the result of that is hopefully peace of mind and family harmony and relaxation, less stress. I think Carol has spoken to you before about how we practice what's called life. But since I'm kind of talking about the legal plan, how it kind of fits in, the biggest cog in this wheel is the social medical. That is what drives most people's need to plan or fear because there's been a medical event, or that hey, a person just can't get the kind of connection to resources that they need. And then you've got these other 2 smaller wheels, the legal wheel and the financial wheel. Well, we're going to talk about the little legal wheel today, but I put this slide in there because I wanted it to kind of hit home that a lot of people come in and they say that they need legal services, because they know they're supposed to have a power of attorney or they're supposed to have a will. But just because that is the overarching belief, what we really look at is where are you socially, where are you medically, where are you financially, and then we fit the legal documents to that situation rather than come in, make the legal documents, and then let life happen. And I think that helps because we have the end in mind. We're planning at the very beginning with the end in mind. And so let's talk about the very first phase of basic planning. What kind of legal documents do you absolutely positively need in your filing cabinet or in your safety deposit box? A lot of people, whenever in a real live audience, I poll people and I say, okay, what is the most important legal document you think you need to have? And hands will go up and they'll say will or a living will. And those are all good answers. My answer, and this is in my humble opinion, the most important legal document that you can have in your portfolio is a general durable power of attorney. And the reason for that is that if something would happen to you, whether you're 85, 65, 25, you could step off the curb and get into an accident and land in the hospital for maybe an extended period of time. And without that general durable power of attorney, nobody else could take care of writing your bills for you, to keep your utilities on while you're laid up, to take care of insurance claims, to take care of tax time if that accident happens during that time. So to me, that document is now, it's today. It doesn't worry about the estate plan. It worries about the business of you if you can't carry out those tasks. So the general durable power of attorney is just one document in what we call advanced directives. And advanced directives is a fancy schmancy lawyer term for powers of attorney. For general durable power of attorney, which is financial in nature, healthcare power of attorney, which obviously is healthcare. We have a living will that we put in that package, which governs end of life decisions, and we'll talk about that a little bit. We also have a funeral declaration in there, which is important in that even if you don't know all of your wishes with respect to a ceremony or what scripture you'd like to have read or flowers or anything like that, if you've made a decision for burial versus cremation, that's such an important legal decision that it's important to have that in writing and to declare that in advance. If you don't have these advanced directives and something happens to you, then your loved ones are required to get a guardianship in order to help you make these decisions or help you write those bills and keep those utilities on. So let's kind of look at the comparison of why you would want to get advanced directives in advance versus just doing nothing and let a guardianship happen. The biggest, most important reason I preach advanced directives is because a guardianship proceeding is public. And the guardianship statute was written by lawyers. And in that statute, you can't show up to guardianship court without a lawyer. Wasn't that brilliant? And you have to pay that lawyer. So it's more expensive. A guardianship is, you have to ask permission before you do anything for your loved one. So if I want to, let's say my mother's had a stroke and I want to move her from a rehab facility into an assisted living facility, I have to ask permission of the guardianship court. And you know what? The answer isn't certain. The guardianship court could tell me no. They also supervise whatever I'm doing. So I have to account every 2 years for every penny spent on behalf of my mom, for instance. Advanced directives, for the cost of the first hour of the attorney's time in guardianship court, you could get the full package of advanced directives, your directions made in advance, and those conversations are private. They're obviously more economical. You can retain a whole bunch more control than the judge telling you what you can or can't do. And you can customize those powers. You can make it to where let's say you're going to name your daughter as your power of attorney, but you're just fine right now. In fact, this is exactly what I have. I have a power of attorney in place that is effective immediately for my husband. So my husband could step in and take care of my affairs. But if my husband is not available, I have my daughter as backup. But my daughter is not going to be the power of attorney, the backup power of attorney, unless a doctor says that I am incompetent or that I don't have the capacity to make my own decisions. So you can really make those advanced directives fit your situation, and more importantly, fit your wishes much more effectively than if we are left with no planning in this area and we're headed to guardianship court. So that is phase one of what I think is the most important kind of set of planning documents to have. So I am not driving very well today. I apologize. Some frequently asked questions around these documents, and I should have started out the entire program with, I only have one rule, and that is if you have a question, pipe up, raise your hand, interrupt me, I don't care, because these things mean more if you're applying it to your own set of facts. But a lot of people ask, what is the difference between a living will and a DNR? And that is a critical question because of the far-reaching impact. A lot of you may have already signed a DNR, or a loved one has signed a DNR. And quite frequently, as you're being wheeled into the emergency room, you're being asked to sign a DNR, which I think is a really tough time to ask somebody to sign a legal document. But what a DNR is, it stands for do not resuscitate. And the DNR is usually kind of on your refrigerator or in your house somewhere. So when a first responder comes in to give you assistance, they see the DNR, and that is their direction to perform life-sustaining measures once. And if that doesn't work, then to cease. The living will says, hey, don't do any life-sustaining measures, but only after a licensed physician has certified that death is imminent, I have an incurable illness, disease, or injury, and the only thing keeping me alive is a machine. Let's say I'm on a ventilator or a bypass. So only after those things, which are pretty dire, very dire, this means truly end of life, only after a doctor has checked those boxes will no other resuscitation happen. That's very different than not getting CPR in your kitchen. Okay. So a lot of people think a DNR is a living will, and it's not. It's two very different time frames. So not to say that you wouldn't want to sign a DNR under certain circumstances. I just want you to know what you're signing and what it means. For instance, I have clients, terminally ill clients who have been rushed to the hospital several times, resuscitated, and they're just worn out. They're just tired. They're going to sign that DNR knowing that they may not get CPR all the way to the hospital, and that's okay with them at this point in their life. But I want to make sure that you know what you're choosing. Another frequently asked question is funeral arrangements, cremation, burial, or other arrangements. I think, as I foreshadowed, I think these decisions are really important to make in advance and to get in writing. I've seen too many families where one daughter says, Mom did not want to be cremated. The other daughter says, yes, she absolutely did. She told me, we discussed the arrangements. There's nothing in writing. So, and they're both next of kin. So the funeral home, they can't do anything until there is agreement on next of kin. So now all of a sudden we have a loved one lying in a morgue for way too long while the family battles this out. And I know that wasn't intended. I know that if we just would have gotten these instructions in writing, we would have been fine. So it really prevents a lot of that tragedy in already a really sad and upsetting time. So that's my pitch for advanced directives. I think it's that's a no-brainer. You have those documents in place, and I think that's important. The next phase of planning, the second phase of planning, is what most people think is estate planning, and that is, do I need a will or do I need a trust for what happens after my death? So let's compare a will versus a trust. And so you can kind of lay your scenario or lay your facts over the rules.
Hey, Lisa, before you go on, I had a question I wanted to ask. So if someone has a power of attorney in place, but they don't have any of these other documents in place, can the power of attorney then work on these documents? Or is that how that works?
Great question. So, and we've had this situation come up. So we'll have a client who has a power of attorney from a few years ago. However, that power of attorney is not able to sign a living will. The individual has to sign the living will. The power of attorney cannot sign a last will and testament like we're getting ready to talk about. So no, a power of attorney can't create more advanced directives than what is already in the power of attorney. So sometimes we'll have folks bring in the 1 or 2 pager power of attorney, and the thing that we need them to do for the agent is not listed in the power of attorney. So now, in order to get whatever task done that we need done, we still have to go to guardianship court, even though we've got a power of attorney, but it didn't give him the power to do what we needed to do. Okay. A will, do we need a will? Do we need a trust? Or can we get by with neither? What is a will? A will is a written set of instructions of what to do with your stuff after you pass away. A trust is a written set of instructions of what to do with your stuff when you pass away. So what's the difference? If I hold my wealth or my assets in trust, upon my death, my trustee can distribute my estate privately and very, very quickly. If I don't hold them in trust, my assets have to go through probate court or probate administration. This takes a minimum of 9 months and usually is about a year or 2. The cost associated with probate is also pretty exorbitant. It costs anywhere between 4 to 11% of the amount of the estate. So if we've got a $2 million estate, that's salty. Whereas in a trust, all of those fees could be avoided. And like I said, the wealth passes to the next generation privately under a trust, but they're public in a probate court administration. However, there are some times where a will is very appropriate, and it's the instrument that we do choose, even though we run the risk here of probate. Let me give you an example. If a client comes in and they own, the extent of their estate is a house and a life insurance policy and an IRA. I can get the house transferable upon death through what's called a transfer on death deed. I can get the life insurance transferable upon death by listing a primary beneficiary and contingent beneficiaries, just in case something happens to my lineup. Same answer with respect to the IRA. I can get beneficiaries put on the IRA as well. So now upon my death, all my assets pass automatically as per my directions, and I don't have to take any assets through probate court. So there are some circumstances where clients who hold their wealth very simply and streamlined, I can get by without doing a trust. If I have too much complexity in how I hold my wealth, or if I want to do more complex things with it into the next generation, I usually need a trust. For instance, if I have a special needs child or grandchild, I need to pass it in trust. If I want to give to charities, if I want to do more complex things, the trust is the way to go because it can be completely customized to whatever you want.
Lisa, I had another question. Sorry about this, but I have past experience with an attorney that had advised that we didn't do a trust, but that we said in the will that upon our death, a trust would be created. Is that a different thing? Is that advisable? Is that a bad idea?
I prefer to put it in trust from the very beginning. And the reason is, even though you have a trust embedded in the will, those are called testamentary trusts. Even though you have a trust embedded in the will, it still has to go through probate court to create that trust. Well, you could have created that trust during lifetime and have avoided that probate. Now, with one very, very important exception, there is a law in Indiana that says that if a spouse passes away, they can leave everything in what's called a supplemental needs trust for their surviving spouse. And all of those assets would be preserved from any long-term spin down. So we call those wills with embedded special needs trusts, and we'll take it if we have to go through probate, because that's the only way that we can save all of those assets for a spouse who may be ill. For instance, let me make that less hypothetical. I have a couple we just yesterday met with. The husband is in memory care and the wife is doing fine, but she has a history of heart problems. So what we've done is we have put all of the marital assets over into the name of the wife. We think the husband who's in memory care will probably decline faster and will probably pass away first, but we never know. So we are planning for this healthier spouse to have everything in her name. If she passes away, we take all those assets through probate. We put everything into trust for the ill husband, and they're preserved. He's permitted to get long-term care benefits to help pay for his very expensive memory care stay. So that was probably more information than you wanted from that question, but that's how those work. Now, there's the third phase of planning is kind of, I call it advanced planning. And that deals with things that are not just your garden variety estate, but if you have business assets, if you have special needs children or grandchildren in your family, if you have some risk management issues where you have a large amount of assets or large amount of collections of things, cars, coins, whatever, that we need to make sure are insured and passed to the next generation without busting the collection. But the biggest bucket of advanced planning is what I call asset protection planning. And what asset protection planning addresses is what happens if I need long-term care down the road, and will I need to spend all of my assets down before I'm able to get any help paying for care? And so that begs the question, when do you start doing asset protection planning? I tell folks who, let's say I have a married couple who comes in, they're 55, they're going to do some of that will versus trust planning, and they're going to decide, you know, we're going to put everything into a trust, and if something happens to us, we're going to avoid probate, all the money will get to our kids. That's great. They're not ready yet to do asset protection planning. Asset protection planning, I think you start revisiting that issue or visiting that issue mid-70s or so, unless there is a diagnosis that we know will progress into the need for care, a Parkinson's, a dementia, whether it be an Alzheimer's or a non-Alzheimer's type of dementia, or if we've got some significant mobility issues, history of stroke, those kinds of things, we may want to start that asset preservation planning earlier. I think I'll skip that question. I think I'll skip that question too. Let's get straight to asset protection. What do we need to know about whether we are prime or ripe to do some asset protection planning? We need to know this. We need to know that currently there are 12 million people in this country who receive some sort of long-term care. And long-term care is just defined as assistance with activities of daily living. Do you need help getting in and out of bed or getting into the bathroom? Do you need help with transferring, with medication management, with meal preparation, those kinds of things? We also know that in the next couple of decades, 78 million baby boomers will need long-term, or will be coming of age, and 72% of them will need long-term care. That means statistically, A system that is serving 12 million people now will be asked to serve 50 million people over the next 10, 15, 20 years. That to me translates in one who plans the most proactively will have the most options to get the best care at the least financial impact. And care costs are no joke. If you've been a caregiver, or if you have been friends with somebody who's gone through this, in-home care, everybody wants in-home care. I've never had a client come into the conference room, sit down and declare, I want to go to a nursing home. No, we want to stay at home as long as possible. And in-home care is one of the most expensive levels of care there is. So let's say there's an in-home care agency who can provide care for $20 an hour. They won't come out and provide the 1 hour of care that you need at the exact time that you need it. They normally require minimum 3 hours shifts at least 3 times a week to kind of get into the program. That puts you at $800 a month just for the bare minimum. So, and you can kind of see these amounts. Assisted living is an interesting concept. When I first started doing this area of law, assisted living was not what it is today. It's not on every major intersection, but the concept behind assisted living is brilliant. Back when I started, there was the nursing home, and that was it. And nobody wanted to go to the nursing home. It was a hospital type scenario. Assisted living addressed that fear and that dread and said, you know what, you can receive care in a really, really nice place that serves dinner on linen tablecloths and provides activities and transportation. So it fit that need perfectly. And it answered the question of how am I going to afford this care? So now assisted living is in-home type care, but you pool your resources with all your neighbors on that floor, and we pay for 24/7 care together collectively. So it drives that price down. So, and since then, even memory care has popped up. That is usually a locked unit that has a very high ratio of care providers to residents. It's excellent care if that's what our loved one needs. And then of course the nursing home, everybody's always afraid of the big kahuna. And just to kind of put some, to piggyback on my initial story, that call that I got about my grandmother happened after my aunt and my mom were sitting in the business office manager's office at the nursing home, and they got the first month's bill. And my aunt exclaimed, we'll never be able to afford this. And so, so the business office manager wheeled her chair around and began to apply for Medicaid for my grandmother, who of course was denied because she had a farm and she had assets, but the business office manager heard that they will not be able to pay my bill. So that started the whole ball of wax. She was denied for Medicaid. She had to private pay for several months until we could get everything kind of figured out. But those are the kinds of care costs that can provide such sticker shock for people that really makes people afraid and nervous, especially married couples, when a healthy spouse is left home saying, how am I ever going to afford paying for my spouse's care and still keep myself alive? So care costs are a driving factor for asset preservation planning. And this statistic is really indicative. The average nursing home stay is 2 years, 5 months. That's expensive. And you've got to realize most people don't go from working a full-time job to being in a nursing home. You usually consume care and pay for care along the way until you need that high level of care. So this could be a pretty expensive journey. And that's one of the things that we are continually trying to help figure out, how going to pay for the long-term care. That care, meaning that you're not spending down your assets at an alarming rate. And how do we do that? If we're early enough in the process, we explore long-term care insurance. We explore all types of benefits that may be available, whether it's long-term care Medicaid, whether it's in-home care Medicaid waiver, veterans benefits. And then we also just employ some asset preservation strategies. So let's talk about what those asset preservation strategies are. There's two types of clients that if they're coming into our office driven by a care concern, they're either in crisis, we need care right now, or they're in pre-planning mode. We want to make sure that if we ever need care, we are pre-planned. If we do have time to plan, what are we planning for? We're planning for what's called a 5-year look back, and in some instances, a 3-year look back. I don't know if anyone's ever heard of that, but essentially, if you do asset preservation planning and place your assets in an asset preservation trust and 5 years elapses, none of those assets will be exposed to spin down. They will all be preserved, and you would be immediately eligible for any long-term care benefits that are available. So that's kind of the clock that we're trying to get ticking right at the right time. We're trying to beat that 5-year clock. And essentially what this diagram is, it's kind of a cartoon version of what an asset protection trust is. So let's say I am interested in doing asset protection. I'm the grantor. So I'm going to be in the red rectangle. I'm going to create this blue circle trust. I'm going to put all my assets in that blue circle trust, and imagine that as soon as the red triangle puts all of our assets in the blue circle trust, there's a brick wall that gets built up between the grantor and between the trust. The grantor can't reach in and get her assets back, and the trustee can't give the assets back to the red triangle. However, the trustee, who, if we're able to plan, would be an adult child, a trusted advisor, somebody that is on your page with respect to a long-term care plan. A trustee can reach in to that blue circle trust, distribute funds to the purple star people, who are the lifetime beneficiaries, and then the lifetime beneficiaries, who are usually your children or your trusted advisors, would give it back to me, the red rectangle grantor. So just because I have divested myself of ownership of these assets in order to get that 5-year clock ticking, I still have access to them through that more comprehensive long-term care plan. If I pass away, any assets that are in my trust flow out to the orange star people, which are basically my heirs. Whatever my estate plan was going to be, I'd like to divide it equally amongst my children, or I'd like to make some charitable gifts. So it's kind of a comprehensive plan that accomplishes staying out of probate, making sure I can still get my money back if I need it, and starting that 5-year clock ticking for asset preservation.
So Lisa, if the trustee is your, can you go back to that slide? I'm sorry.
Yep.
If the trustee is, say you have a son and that's your trustee, but he's also one of your beneficiaries. So if he's the trustee, he cannot give you anything. It has to go to somebody else and then to you. Is that how that works?
So let's use your example. Son is my trustee, son is my lifetime beneficiary, and son is my orange star remainder beneficiary.
Okay.
Son can give it to himself and give it back to me.
Okay.
That's how it gets back.
Okay.
Even though he's read for all 3 of those roles and he's a beneficiary of the trust in all aspects, he also knows my long-term care plan and wants to preserve assets for me as well as his beneficial interest.
And what would happen if the trustee, do you have like a backup trustee in case something happens to the primary trustee?
Yes, we have backups upon backups. If you have, I have some clients who say, I'm not going to discriminate against any of my kids. We're going to have 3 co-trustees. They're all going to serve at the same time and work through these issues together. I have some clients that say oldest is first, second oldest is backup, youngest is second backup. Okay.
Lisa, if you have a couple that has a significant age difference, where one's not going to need care for a long time, would you use a trust like that, or would you go back to that another type of tool?
There's no reason we shouldn't use that same trust, because, and I would answer it differently if I couldn't get that money back out to the grantor. If If, however, we're still not comfortable with the lack of direct access, then what I would do is I would probably do one of those plans where the assets get all transferred over to the healthiest spouse, and then do that will with the special needs trust inside of it in case something unfortunate would happen to that healthy spouse, then everything's protected for that more sick spouse.
Okay.
What if you walk in and to the office and we need care right now? We've had a medical event, or the need for care is very, very imminent. What do we do then? How can we preserve the assets because we don't have 5 years? So what kind of techniques can we use? The first rule is that if we have a married couple, the spousal impoverishment law says we can preserve 100% of the assets back to the spouse who does not need the care. Now, that is something that is not told to you when you're in the business office manager's office. It's not told to you when you're signing up for in-home care with SEQOA or someone else. The spousal impoverishment law is a federal law that basically says there are funds available to pay for the care of that first spouse, because if we don't allow those benefits to flow to that first spouse that needs care, we are going to impoverish the healthy spouse. And the healthy spouse will cost more in the long run. So if the healthy spouse has to spend their whole life savings paying for her husband's care, she's going to need transportation assistance, food assistance, healthcare benefits herself. She may need living expenses. So it is a conscious effort to prevent spousal impoverishment and allow that first spouse to get their care paid for. What if we only have one person? There are single person preservation rules in place also on the federal law books. And the rationale behind those is this: the entire reason for long-term care is rehabilitation. The care is intended to rehabilitate you and get you back out into the community. Even if that community is an assisted living community or in-home care, or go back home, but you need a lot of in-home care. They would rather, the folks providing these benefits, the government that is providing these benefits would rather you be anywhere than in a nursing home. So they want to rehabilitate you and get you home. If you have to spend all of your money while you're in the nursing home rehabilitating, you have nothing left to go back out into the community with. So the rules allow us to preserve at least 50%, sometimes up to 80, 90, and there are circumstances where I can save it all, it all depends on where you are when you come see me, how much I can preserve as a single person. I know I'm getting toward my time, but I want to just say a couple things about gifting, because a lot of folks believe that the way they can become eligible for long-term care benefits, or the way they can stay out of probate court, is by giving their assets away. So I'm just going to put my house in the name of my daughter. I'm going to give my $100,000 savings account to my daughter. Let's play that out. Let's say I've chosen to do my own DIY asset preservation plan. Here, honey, here's my 100,000, and I've signed my house over to you. Just let me live in it. Okay, perfect. Well, my son-in-law now owns half of my house and has half of my money because they divorced. And as marital property, he was entitled to half of everything that my daughter received. That does not mesh with what I wanted to accomplish with my long-term care plan. So, and that's a very, very real exposure and concern. What if my daughter predeceases me? Now all of my money goes into her estate. And so do I make a claim in the estate that I want my house back? I want my money back. What's my right? Because she's got her own will and it gives everything to her husband or to her children. What if she has creditors? The creditors don't care that the money in her account is really mine. They just know that there's an account with her social security number and they have a debt that they are going to collect upon. So there goes my money. What if somebody sues her? What if she's in an accident and they get a judgment against her? In some unfortunate circumstances, I've had cases where mom's given the money away and daughter, very well intended, is just a little short on college tuition for her kid, or the basement flooded. I just need 10,000 here, 3,000 there. And all of a sudden, when I really need my money back, it's not quite all there. But the biggest reason I say don't give the assets away is, let's take the house, for example. Let's pretend that when I bought my house back in 1975, it was $20,000, and I've lived in the house the whole time. If it sold today, it would sell for $120,000. If I give it to my daughter, she only gets the cost basis of what I have. So when she goes to sell that house, she has to pay capital gains on $100,000. That didn't need to happen. I could have left my house to my daughter through a transfer on death deed or through my trust, and she would have gotten a step up in that capital gains basis. So we can eliminate those kinds of tax consequences if we don't just willy-nilly give things away.
Lisa, can you clarify on the tax issues for houses? So if it's your primary house and you sell it, you do not have that capital gain. Is that true? It's only when it's an additional property?
So you have a lifetime, currently under the current legislation, you have a lifetime exemption of $250,000. And a married couple each has their $250,000. So if we sell our marital home and we have $100,000 cap gain, that only takes $50,000 off each of our lifetime exclusions. So our next home, or maybe our rental home, we're going to sell and we'll get some cap gain. We just chip away against our lifetime exemption. Once we've used up our $250 each, then we're paying cap gain on anything else.
And prior to that being the rule, that it used to, well, just personally, we sold a house and we paid taxes on it like 25 years ago. So that then we still have the full, in our case, the full 250 each.
Yes, yes. And that cost, I should add this, the cost basis in my example, when I bought it for 20,000, I could have over the years maybe put another 50,000 into it for repairs or remodels. That counts toward my basis. And my daughter would get that if I did hand it over, but I can get her to zero cap gain through a transfer on death deed or through a trust. Okay, the fourth phase of planning is the life care planning. And I think Carol's talked to you about that before. That's where we make sure we have everything in place legally, everything in place financially, and then we really attack medical, because that's usually where the most stress, that's where most of the disconnect and the unhappiness comes into play. And normally when we're evaluating a family to see whether life care planning is appropriate for them or whether they don't need that level of service, we ask about warning signs. We ask, how's driving going? Are there any dents and dings in the garage door or in the car? We'll have somebody go out to the home and they'll see that all the furniture has kind of been pushed into the center of the room to be used to help get to the next couch or to the next chair or to the kitchen. Some hoarding behaviors begin to happen as we age or as we become ill. A lot of times dementia warning signs are financial paranoia. You'll find wads of cash in suit coat pockets or in sweater pockets. Or I had a client just the other day call up and say, oh my gosh, I just found a shoebox of money in the freezer. What do I do? I said, well, now, how long's it been there? She might have been doing that since before she got dementia. That might be her savings kind of philosophy. But those are warning signs that really start ticking off. We may be in a care situation here. We may be in a social medical situation. Hygiene is a very telltale sign as well. When somebody starts losing the gumption to care for themselves, then it may be time for some tough conversations. And really those tough conversations we've kind of talked about up above, the decisions about who wants to serve, who you want to have serve as your power of attorney, what kind of arrangements do you want to have for your funeral? When and if you ever do need care, who do you want to be able to come see you? Who do you want not to be able to come see you? What kind of care do you envision needing? And then we can form these documents that really lay out your path in advance, and you can be sure that your wishes are being adhered to because they're part of that more holistic plan. That's all I have today. I know I fire hosed you with a whole bunch of information, but does anybody have questions?
So can you explain if POD accounts, do those bypass probate, or how does that work?
Yes, very good question. So it's same concept. If I put my house with a transfer on death deed, I can put my checking account with a pay on death designation. So, and let me kind of clarify that, because those checking accounts or financial accounts are really confusing. A client will tell me, hey, I put my daughter on my account. What does that mean? Does that mean you've made your daughter an owner on your account? Because we don't want her to be an owner because she's susceptible to those risks, divorce, creditors, those kinds of things. Did you put your daughter on as a signer on your account, meaning she can sign checks, but she doesn't have an ownership interest in the account? Or did you put your daughter on your account as the person who receives the money inside the account upon your death? So is it ownership? Is it signing power? Or is it a pay on death designation? And I think what the breakdown is, when you go into the bank and you say, hey, I'd like to put my daughter on my account, it all depends what that teller thinks that he or she heard. Any other questions?
So when you have an estate that is, it comes to that point in time, how do the taxes work on like just a general will?
Good question. Indiana abolished the inheritance tax or the death tax back in June of 2014. So currently we don't have to worry about inheritance tax anymore. And that was a salty hit, really was. So that's a good thing for families. I will tell you that repealing the inheritance tax really kind of gut punched a lot of counties and local localities. And so because the politics, it may not always be repealed, especially small counties, rural counties in Indiana have really lobbied to bring it back. Now that's the state death tax. There is a federal estate tax, and that's called the federal gift and estate tax. So it's a combined or a unified concept. If I give away anything, or if I die with an estate, those things are counted toward that estate tax. So how does it work? Currently, the legislation is you don't have to pay any gift tax or estate tax for anything under $11 million a person. Whew, I'm just under that, so I don't have to. No, nobody's going to be paying gift and estate tax in this real world, right? However, when I first started doing estate planning in the early 2000s, that was not 11 million, it was 600,000. So there are a lot of estates, there are many, many estates today that would be over that 600,000, and now they're beginning to pay estate tax. So there are planning techniques that you can do if you do them in advance, where we can minimize the risk of paying that tax and kind of avoid it, especially after the death of the first spouse. And we can work to crunch that down. Now, like I said, we're at 11 million. However, it's a creature of politics. And I've got to believe that based on where we are in our economy, legislation will bring that down. How far down? I don't know. It'll depend on what people can get through Congress, but it will be coming down.
There's a question in the chat too. What needs to be done if you want to change the person on your POA?
You can do one of two things. You can amend your power of attorney and just name a new power, Or you can restate your power, which if that came into my office, the first thing I would want to do is I'd want to look at the power of attorney. Do we need to beef it up? Do we need to make sure that we got the kitchen sink in there? And then while we're beefing it up, we can also change the power of attorney. The only limitation to that is, can you still sign legal documents? Are you competent to sign legal documents? You can change anything you want.
So how do you determine if someone is competent or not? Say they have dementia, but they have periods of coherent
lucidity. Yeah. So this, you can ask this question to 10 different lawyers and you're going to get 10 different answers, but here's mine. I am a big believer on keeping things in the family as much as possible and keeping things private. This is your life. This is your competency. And so I believe that competence is a continuum, that you may get up in the morning and be really sharp, but by the end of the day, fatigue, nutrition, dehydration, you may not be competent by 4:30 in the afternoon. I have no problem signing legal documents at 8:30 in the morning that I wouldn't allow to be signed at 4:30 at night. So that's my philosophy, because I want to keep a family out of guardianship court at all costs if I can. How do I assess that to make sure that there's not a child who comes back later and says, mom should never have signed that POA? I will do this. I am lucky enough to have people like Edna Rausch and Carol Applegate in my office where I can say, hey, can I get somebody to come in and do a capacity evaluation? Whether it be an RN, whether it be a licensed social worker. We have evaluation packets where they go through the interview with that person. And as a lawyer, I administer kind of a MASH unit mini mental myself. And if I do that and I'm not really confident, I'll call that capacity evaluator in, and obviously we get all other people out of the room. No children are going to be in there influencing anything. We'll go through that evaluation. If there's still concerns there, we'll refer to a neurologist for a full assessment. And I've done that where I didn't feel comfortable. I brought a nurse in from our staff. She was iffy. We sent to the neurologist. He came back and he passed. And so now we're creating the documents.
So is there ever a risk of a challenge when so say you guys all think, yeah, it's all great, but then a family member X comes in at the reading of the will and doesn't like it, or what have you?
Yeah, in fact, if you'd like to see how that plays out, I'm in trial beginning May 4th on this on this very issue. But we're going into trial with these things. We have one neurologist who did a mini mental that said 27 out of 30. We did a neurologist that did a full-blown assessment that said, yes, he needs help with major financial decisions, but he has testamentary capacity to say who he wants to inherit. Later he wanted to amend again. So we had another neurologist do another assessment about a year and a half later, said the very same thing. I feel really good going into court on May 4th with all of that medical evidence. But anybody can sue anybody for anything. So that's why we're defending ourselves.
Yeah. All right.
These are good questions. I love it.
So if anybody else has a question, you can either drop it in the chat really quick or just speak up if you have one that you want to share with the group out loud. But while we're waiting to see if anyone has any additional questions, I wanted to thank, Maria for coordinating a lot of this, and Lisa for presenting today. And of course, Carol's not here, but she's been a big part in the planning for the entire series. And this was particularly interesting to me. So I'm hoping that people that were not able to make it today, and I did have some people email me in advance, that they will be able to watch the recording and find it helpful to them as well. So thank you very much for that.
Well, good. If anybody's watching the recording and questions pop up, get with me or Maria, or we can answer them pretty readily.
Yeah, I was going to say, Barb is going to send out some information that we have on our firm, some things that we have talked about in past sessions, just some general information. and then all of our contact information as well. So if you have questions, we also do complimentary consultations. So if you want to bring your own scenarios to the table, we can sit down. You have an hour with us at no charge, and we can talk about what it is that you or your family needs to begin looking at for planning. So those are all, of course, open to everybody. And we have, which Barb will send this out as well. She does every month, a general life care planning class that we do, that's more geared towards social interaction. And next month is flower arrangements for Mother's Day. So you'll be getting that flyer as well.
Yeah. All right. Well, if we don't have any questions, we're about 3 minutes early, but I guess we can all have a few minutes back, get some lunch or whatever it is. And yeah, we will get this out as soon as we can to people on our website. And I thank everyone who attended, especially all of you that attended all 3 sessions. And thanks to Applegate Dillman for all that you've done, and have a great week.
Thank you, Barb. We appreciate it.
Bye.
Bye-bye.